Hello, everyone, and welcome back to Intro to Criminal Justice. We are in Chapter 3. This video covers Chapter 3, Criminal Law. Of course, I hope you enjoy.
Rule of law, it means that we're all equal in front of the law.
When everybody's free to say what they want. Justice?
The rule of law is holding people accountable to the law.
The law must emanate from the people. Look, the law lives in the consciousness of the people. If you don't have that, you don't have law.
In countries where the rule of law is absent, ordinary people do not have access to the justice system. Imagine you're walking down the street and you're suddenly approached by plainclothes police officers from a secret security agency. You're taken to a prison, you're tortured, you're abused, you're held without any legal grounds, and you have just simply disappeared.
The rule of law emanates from the people of a nation. Yet there are countries where the rule of law is not a common practice.
Without the rule of law, you have a nation where its citizens' fundamental rights and well-being are not protected.
The United States Institute of Peace believes that rule of law is the lifeblood of a society.
One example of how we bring in voices of the people into the process is through justice and security dialogue, where we bring citizens, government, police, and others together to build trust, identify the rule of law challenges, and come up together with joint solutions and strategies.
The rule of law is more than about one person, or even groups of people. The rule of law is a process, but once constructed can be enduring.
What we're seeing in the world is people's demand for a voice in decisions that affect their lives. For a society that provides justice, security, and accountability for everyone. In other words, a society that abides by the rule of law.
Welcome everyone, and welcome at this mini lecture in which we will explain the difference between substantive law and formal law. As you all know, law is there to organize just behavior. However, we do this mostly in two distinct ways. On the one hand, we have the rules of the game as such, the content of the law, we call that substantive law. And on the other hand, we have the rules to maintain the rules of the game, and that is called formal law. Well, let's give you an example. If there is a burglar stealing something from someone else, we all know that stealing most likely is forbidden in most societies. That is exactly substantive law. Thou shalt not steal. However, only the substantive rule in itself is simply not enough to create a society in which we can organize just behavior. We need some other rules, some procedural rules, to make sure that we maintain this just behavior. So, if I arrest this burglar, I need to know what I can do to give him a fair trial and at some point maybe put him in prison. There is a widely shared principle we call unus testis, nullus testis. And that means as much as with only one piece of evidence, I cannot just put you in prison. I need more than one piece of evidence. This rule is an example of formal law because it contributes to the maintaining of substantive law. So, to sum up, the rules of the game, the content in itself is substantive law, and the rules to maintain this substantive law is called formal law. Well, I hope you've learned a few things, and thank you very much for watching.
Welcome to another video in the crime series from the Wimbledon channel. Today we're going to look at the elements of crime. The two fundamental elements that need to be proved for something to be a crime are mens rea and actus reus. These are both Latin terms meaning guilty mind and guilty act. Let's look at mens rea to start. This is the hardest element to prove because it has to do with the mind, and we can't always tell what people are thinking or what they know. Fundamentally, mens rea looks at the motive and intent of the person who's accused of committing the crime. In order to prove mens rea, you need to show A, that they meant to do it, and B, that a reasonable person would have been aware of the consequences of their actions. You might be sitting there at this point thinking to yourself, well, how are they going to prove that I meant to go over the speed limit in my car? Well, that's an example of what's called a strict liability offence. These are offences where you don't need to prove mens rea. That's because they're usually summary or less serious offences, and there's a greater volume of these. The logic goes, if you have your driver's licence, you should always have control of the car, and it's assumed knowledge that you are to obey the speed limit. So we don't care if you meant to or not. You shouldn't have been speeding. Essentially, this speeds up the process of those people being charged with those types of offences. Now let's look at actus reus. This element of a crime is usually much easier to prove and comes down to the simple fact, did they actually do it? And usually the answer is much easier to find out due to physical evidence, witness testimony, and forensics. Again, you might be sitting there thinking, well, maybe they can prove that I did an act. That doesn't actually mean that the consequences of that act were caused by my actions. This question is a subset of actus reus, and it's called causation. In other words, was the crime a direct consequence of their actions? Or perhaps was it merely an unfortunate coincidence or caused by something completely unrelated? For example, I might be angry with my uncle at Christmas and hit him with a baseball bat and he has a heart attack and dies. Now there's every chance that that's what caused the heart attack, but perhaps my uncle was incredibly unfit and would have had a heart attack anyway. Or perhaps we have a really strong family history of heart attacks, in which case that needs to be taken into account as to whether I'm charged with just assault or with manslaughter. In other words, did hitting him with the bat cause him to die, or was it an unrelated consequence? In order to prove actus reus, you need a direct link from action to result. So in any court case, the prosecution is trying to prove mens rea and actus reus, because they're the two fundamental elements of a crime. This has been another video for the crime series from Wimbledon Channel.
It's crazy to plead insanity, says one law professor. This plea rarely works, and yet some of the most famous mass murderers have attempted it. Just this month, Eddie Ray Routh, the killer of American sniper Chris Kyle, was deemed sane by the jury despite his insanity plea and convicted of murder. So why is it so hard to prove insanity? Well, first of all, pleading insanity means that you admit to the crime itself, but you're not responsible because you're insane. Also, you should not be put in prison or sentenced to death. The problem is that it's hard to prove insanity. In most U.S. courts, the burden of proof is on the accused. A defendant must prove beyond a reasonable doubt that he or she was so mentally ill that they didn't know right from wrong during the crime. In the Routh case, during the closing argument, the prosecution highlighted the fact that Routh did have enough mental capacity after the murder to order a burrito at a fast food restaurant. If he was insane, according to the prosecution, this food trip would be unlikely. Another reason the insanity plea usually doesn't work, according to several lawyers, is that jurors are hesitant to acquit people who have committed horrible crimes. The insanity plea at its basic level is a plea of innocence. People often feel that someone who is aware that they committed murder deserves to be convicted, and that the insanity plea is an easy way out. Ralph confessed to committing murder, yet pleaded insanity. Despite a history of schizophrenia and PTSD, the jury convicted him. Similarly, in May 2014, David Tarloff also tried the insanity plea after he brutally killed his psychologist. He, too, suffered from schizophrenia, necessitating several hospital stays. But again, the jury found him sane and guilty. A 1995 report from the American Academy of Psychiatry and the Law says that, on average, insanity pleas are raised in less than 1% of criminal trials, and only about a quarter of those pleas are successful. Often the media frenzies over famous murderers who plead insanity, like Ted Bundy, and that creates a false idea that insanity pleas are common and that they work. Many criminals do have severe mental health issues, and there are many ways of criminally processing them. But for the majority of cases in the United States, the insanity plea doesn't work out.